Hello and welcome to Economic Lifelines Nigeria. In today's episode, we uncover the legal framework for Nigeria's financial markets and find out how it is supporting the growth and stability of key sectors of Nigeria's economy. The growth of Nigeria's financial markets is closely linked to the increase of commerce in the economy. Trade began under British colonial rule, and for the most part of the 20th century, the laws underlying commerce were borrowed from the British.
I think one of the first laws that we made was the Independent Corrupt Practice and Other Related Offences Commission Act, which established and assured the international community that Nigeria is interested in fighting corruption, particularly in business. Then later we established that was in 2000. In 2002, 2003, we now passed the Economic and Financial Crimes Commission Act. And in 2007, we passed the Fiscal Responsibility Act. We again passed the Central Bank of Nigeria Act. We now passed the Niger Delta Development Commission Act. We passed the act that ensured the abolition of the onshore-offshore dichotomy. We passed the different appropriation acts for each of the years, including Supplementary Appropriation Act. And those were some of the acts that we passed, which were intended to ensure and assure the international community and the investing public that Nigeria is interested in creating a good economic environment for business.
In 1958, the Central Bank of Nigeria was established under the jurisdiction of the Central Bank of Nigeria Act of that same year. The creation of the Lagos Stock Exchange followed in 1960 as a private limited liability company guaranteed under the provision of the Lagos Stock Exchange Act. On June 5, 1961, the Lagos Stock Exchange opened for business with a grand total of 19 listed securities, 3 equities, 6 government bonds, and 10 industrial loans.
The essence of financial markets anywhere in the world is to have regulations that can attract funds, not just from the jurisdiction from where you're operating, but then funds from anywhere else in the world. And you know, capital and funds look for jurisdictions and countries with best business practices where they feel that their investment will be safe. So there's this resolve by our government and the private sector to encourage government and to encourage the legislature to adopt a general political, legislative, architectural framework that is consistent with international best practices that can take a lead from what's being done in other societies, emerging markets, developed countries, and adopt those policies within our own legal framework in Nigeria. So as a stock market grew larger, as international finance became more of a one country international community thing, we needed to move away from legislation that were put in place 20, 30 years ago to evolve laws that are consistent with the demands of the new industrial age.
Nigeria's financial system now comprises of several regulatory authorities, banks, and other financial institutions. The Central Bank, the Nigerian Deposit Insurance Corporation, and the Securities and Exchange Commission are among the country's main regulatory authorities, along with the Federal Ministry of Finance, the National Insurance Commission, and the Pension Commission.
We're examining the situation in the market. We're examining the local challenges we have. We're examining what is happening in the Nigerian Securities Commission. We're examining the functions and the challenges of the Investment and Securities Tribunal. We're examining the actions and the response of the market to some of the shock-creating decisions that may have been taken by the leadership of the country on matters that are capable of affecting the economy. Then we're taking on account of all this before we take final decisions on each of these bills.
Today, Nigeria's financial sector is advancing steadily. The government, through the Central Bank, Finance Ministry, and the Securities and Exchange Commission, has been actively involved in building the nation's money and equity markets, forming security regulatory bonds and introducing treasury instruments into the capital market. A key component driving the reforms has been the Central Bank of Nigeria Act and its amendment in 2007.
I think the role of law and legislation in financial activity and economic growth is quite obvious. You need economic activity based on laws in order to provide some sense of predictability and in order to provide the basis for regulation of financial activity, especially since we're talking about financial activity. So, for example, you have laws such as the Central Bank of Nigeria Establishment Act of 2007. You have the Nigerian Deposit Insurance Corporation Act of 2006. You have a number of laws such as, going back in time, the Banks and Other Financial Institutions Act of 1991, as amended, I believe. And then you have a number of other laws coming up in the horizon to plug gaps that have not been addressed by the laws that are currently in existence. And so, for example, if you take the Central Bank Act, establishes the central bank as an institution and provides the legal basis for its mandate, giving the bank its mandate to maintain monetary and price stability, to issue the legal tender currency, to manage the foreign reserves of Nigeria, to ensure a sound financial system, and to serve as an economic and financial advisor to the government of Nigeria. So that's based in law, and that's what gives us the mandate and the right to undertake those activities. And then together with the Banks and Other Financial Institutions Act, which is actually mentioned in the Central Bank of Nigeria Act, the BOFIA gives us the regulatory powers that the central bank has over banks and non-bank financial institutions.
In addition to the Central Bank Act, several other laws, such as the Investment Securities Act, have supported the growth of financial markets.
I think the improvements have been pretty remarkable because what it has done is that it has made the market a lot more dynamic than it would have been if we had kept the regulations as it was as per 1999. Like I said, if we had a lot of those regulations as we had in 1999, the level of infractions might not have been able to be managed, because the SEC didn't have the bite to be able to go after a lot of those infractions. So what you now had is that they had the bite to allow the market to grow and ensure that there was adequate compliance with what was pertaining then, And then two, the other thing that it did is that on the back of one, you had more knowledgeable people in SEC. The act also gave them more, I would say, preemptive rights. I don't know if preemptive is the right word, but what they had now was they had a lot more latitude to create rules, that could evolve with the market much faster, which is one of the positives of the 1999 Act. So you also had that. So what it did is it actually gave the market scale.
What we've had, especially the post-2008 financial crisis, is an in-depth look at the laws that underpin the financial sector and what could be improved. Now we've seen a revamped SEC who've increased their regulatory oversight in various areas, which has allowed the capital markets to recover. So now you're seeing stockbrokers being able to work with, especially with the AMCON coming in to take over some of the debts. You saw CBN take an active role in bringing the AMCON Act, which basically stabilized the financial market, especially the banks, and moved the bad debts off the bank books. Now, how those are treated is a question that people would ask, but at least from a safe and secure and liquidity point of view, the banks are more secure. So the banks will be able to recover from the bad debt crisis and start building on that, which has brought more confidence in the banking sector in Nigeria. And so I think overall the regulators have done pretty well.
I think the Central Bank Act, if you took it as a whole, it actually gives the governor the leeway to manage the financial service sector, banking specifically. Also, more importantly, the duties of the central bank are clearly defined in terms of protecting the value of the naira, both internally and externally. Now, but if we then sort of deep dive into the details, and I'll give you a specific example, the new banking model, for instance, which really was in response to the crisis, which the global crisis and then the crisis in Nigeria, where the central bank realized that we really needed to have a bit more effective supervision on banks. We also needed to protect, more importantly, the interest of the ordinary depositors. So we had to ring fence the depositors and ensure that in terms of the depositors' funds, it's not used for proprietary business, neither is it used for business which is non-banking that the central bank is unable to supervise. So the central bank had the opportunity, in the broad ambit of the law, to then define that new banking model.
Well, the problems we had in the past with pensions in Nigeria, particularly pensions in the public sector, was the fact that we had difficulty in people who were entitled accessing their retirement benefit, accessing it either after retirement or sometimes after death. And there was a plethora of protest and inability to access retirement benefits. So that now called for the need to review the process, and the PENCOM Act of the most recent act has been an attempt to streamline pension schemes and insurance schemes and ensure that there's a separation. The PENCOM Act has actually separated issues of administration from the custody of the funds. So we now have pension funds administrators on one side and pension funds custodians who actually keep and manage. And because they're two interested parties and they're separate, the intention is that the activities of both the administration of the pension and custody of the funds will be safeguarded by having such checks and balances in the process. Well, the Income Act was an attempt to assist financial institutions and banks in the management of loans that had become toxic loans, and it was a balance between leaving the banks to fail completely and the consequences of that. And it was adjudged that because we had become a market that had massive foreign direct investment in all different aspects of our economy and the banks as well, that it was consistent with the desire to leave this economy as an economy that would be attractive to foreign investors and even local investors, to somehow safeguard those investments as far as was possible. So what now happened was that the toxic loans and the bad debts of various banks were now being taken over by the vehicle, by the asset Management Corporation of Nigeria, which was a vehicle that was set up by law, by the Nigerian National Assembly. The intention was that that vehicle will now take over those assets, manage and dispose of those assets in a transparent, manageable manner in order to realize the best returns on those assets.
Welcome back to Economic Lifelines Nigeria. Before the break, we looked at a history of Nigeria's financial capital markets. Now, despite strong growth and interest from foreign portfolio investors, Nigeria's financial markets are still facing numerous challenges. One such challenge is poor law enforcement.
I believe that as a legislator, part of what we have to do is also to do a self-appraisal. Now, it is we, the National Assembly, that made the law that they said there should be fiscal responsibility. It is we that said they should submit their budget to us. To my knowledge, this budget of these agencies were submitted to us in 2013. And I will not answer this question, but I will ask. National Assembly, we the National Assembly, when this budget of these agencies were submitted to us, what did we do with that budget? Did we pass it for them, or did we leave it unpassed? If we left it unpassed, did we expect these agencies of government to shut down and the people to be sacked? If we did not pass, were the people entitled to make like what President Obasanjo, Emeritus President, would then have said, anticipated approval, and they go on and spend pending anticipated approval? If they spend, perhaps based on what they anticipate will be your approval, and you still have not approved, do you have a standing to go and probe what they have done wrong instead of taking that budget to pass?
I think enforcement is a big issue. I think sanctity of the law, just the whole governance and rule of, is a very big issue, because if we took, even the current issue we have today in terms of the interpretation of what the president can do, can the president suspend the central bank governor, or can the president remove the central bank governor? As a business person, the independence of the central bank is extremely important. So anything that seems to threaten that independence of the CBN is something we should be worried about. And I think we should be especially worried when you are in an economy like ours, where the government is a major influencer of the economy. I mean, we all know a lot of the earnings are controlled by government. So the independence of the central bank is extremely important, that the central bank governor is able to operate within the mandate that has been set up by the law.
Some observers also point to flaws in the legal framework for Nigeria's financial sector.
One big gap that has not really been addressed in the regulatory framework is data protection. There's been an advent of credit bureaus, databases on debtors, but there's no real data protection act in how that data is protected. How, if I, as a man on the street, I can check whether I am in one of those credit bureaus and one of those databases and make sure the information is correct. Because otherwise, I could get a situation where incorrect data could lead to me being refused loans, and there's no way for me to check it. So I think that's one big area the regulators have to address. In terms of competition law, we have SEC kind of have an overview on competition for companies they regulate. But you need a dedicated antitrust or competition law. We don't have that in Nigeria at the moment. And that will not only affect the financial sector, but also other sectors, especially as the economy continues to grow. So I think there has to be a move to try and put in antitrust and competition law. There was one act that was published for National Assembly a few years ago, but it sort of died in the National Assembly. Nothing's come out of that. So I think that's a key issue we have to address. I think also in terms of consumer protection, we have a Consumer Protection Council, but its actual powers and remits are not clearly defined. So you need a kind of ombudsman that the public can make complaints to and have the teeth to actually push things to try and protect the consumer.
The thing that's even most important is the certainty and the ability to plan. I think the second thing that's the most important is the ability to know the rule of law would prevail. So if you took a Nigerian perspective, the laws are one thing, the sanctity of the law, the ability to be able to ensure the law is interpreted, is enforced, is another big thing. And I think if you talk to investors, yes, law is one, but I would be concerned as an outside investor on enforcement, on the sanctity of the law, not that the law is evolved or there's a law and the law is put aside in terms of the judgment or the rule of the government. So I think that really has to be the first focus area. There's nowhere in the world. The law, regulation always trails the realities of the market and the dynamism. But what's important is that you are sure that there's a framework you understand. You're sure that the framework will be applied on a consistent basis. The policy direction is clear. And you're sure that if I was ever in a business dispute, there's a way to resolving and enforcing that.
Nigeria is increasingly becoming an important destination for investment in Africa. But the legal framework could prove to be an obstacle in the way of foreign direct investments.
Operators would always come up with instruments and opportunities. And if you have a situation where the regulator is not as proactive as the market is, then what you now have is that the regulator will be holding down the market, and that on its own is more of a negative consequence than a positive consequence. So that's one. The second one, which is actually the most dangerous one, is arbitrage, and I don't mean arbitrage from a positive perspective, arbitrage from a negative perspective. So arbitrage from a perspective of insider trading, issues associated with that type of stuff. So if you have a situation where the market is moving much faster and is coming up with instruments and is moving much faster, and you don't have regulators that understand these instruments, not only do they not understand these instruments, they don't have the knowledge to be able to ensure that there's regulatory compliance associated with these instruments.
We need to continue to update our legal framework to be consistent with international best practices. So the consequences of our not doing that is that foreign direct investment will reduce. What we produce is not enough to enable us to achieve the growth that's necessary for an economy that is as large as Nigerian economy is. So foreign direct investment is critical in our desire to emerge as one of the most attractive markets in developing world.
I think there are two things. I think firstly, the issue Nigeria has had in the past is not really lack of regulation, is lack of the will to enforce. Nigeria has had sufficient regulation to do a lot of the allegations from the 2008 financial crisis were not acts that were not covered by regulation. It's just that regulation was not effective. And so I think that's the first thing. We need to start enforcing our laws. I think secondly, also need to be able to amend our laws to meet modern advancements. For example, the Evidence Act, before the latest amendment a few years ago, you could not provide electronic means of evidence in the Nigerian courts. And that obviously when you're doing bank trials, where you had bank statements, you couldn't provide that. But the Evidence Act changed that. So I think you need to keep up with modern advances in technology and also modern outlook in banking regulation, especially because of the various international crises, and amend acts to suit that. Because as Nigeria economy grows, Nigeria is becoming more and more international economy. Nigerian banks are in all across Africa. And so you have a situation where, for example, a bank like GT Bank just bought a bank in Kenya. So GT Bank is now regulated not just by CBN, but by the Kenyan regulator, Rwandan regulator. And so the regulators also have to look at ways they can work together with Pan-Africa to regulate a lot of these entities.
Emerging markets are continually evolving, and it is vital that regulators stay ahead of them. In Nigeria, much has been done towards this, but there is still room for improvement, particularly when it comes to providing power to regulatory bodies to enforce the laws. And that's where we leave it for Economic Lifelines Nigeria. Remember, this and other episodes of the program are available on our website at www.cnbcafrica.com. So from me, Keisha Gatari, until next time, goodbye.